Welcome back to Frequently Asked Fridays, where we talk about intellectual property issues and answer your questions with regard to patents, trademarks, copyrights, and trade secrets. This week, we're going to talk about trade secrets, specifically what is a trade secret, how is it protected, and how does that differ from patent protection, and when might you use one as opposed to using the other. With regard to what is a trade secret, basically it is any type of financial, business, scientific, engineering information, things like that, sometimes in the form of lists, formulas, compilations, data compilations, things of that nature typically are subject matter of trade secrets. Two things are required for something to be trade secret. One, the owner of that information has to take reasonable steps to keep that information confidential or secret. And two, the information has to, in and of itself, derive some independent economic value by virtue of it being secret. Probably the best known example of a trade secret would be the Coca-Cola formula. The Coca-Cola formula is something that's been kept as a closely guarded secret by the Coca-Cola company for well over 100 years and is not something that's easily reverse engineered, and it's also something that clearly derives economic value for them, as many people have tried to copy the formula over the years but have been unsuccessful in duplicating it or coming even very close to something that's close to the original. So how do we protect a trade secret? How we protect a trade secret is different than some other forms of intellectual property. There is no registration process for a trade secret. It's kept secret, or it maintains its trade secret status by being kept secret, and that's typically done by agreements, written agreements, contracts, things of that nature. So when you disclose any of this trade secret information to someone as a necessary part of your business, it's important to lock that information down, to have a non-disclosure agreement, a confidentiality agreement, some sort of written document that specifies that this is trade secret information, that it's valuable information, and that the person you're sharing it with is under a confidentiality obligation and cannot share that information with other people, and that there are consequences of disclosure of that information. So that's how it's protected. How is that different than patents? Well, patents, again, are limited in duration. So a patent, and that information is made public. So a patent is good for 20 years, but you have to disclose what your invention is in order to get a patent on it. Trade secrets are kind of the opposite. Trade secrets, the duration of that, it can be a trade secret as long as that information is kept confidential. Coca-Cola example is a very good one. It's been over 100 years, and that's still an existing and valid trade secret. And again, it's not made public, it's not registered, it's not disclosed, and that protection can go on indefinitely. So that's a definite advantage of a trade secret over a patent. However, trade secret protection is usually better suited for things that are not easily reverse engineered. If you've got something that can be easily reverse engineered, patent protection is probably the better route to go. Again, the Coca-Cola formula, that's not something that can be easily deciphered just from looking at the drink itself and figuring out. You can figure out what's in it, but the exact mix of how much of this and how much of that isn't really easy to determine. So that lends itself very well to trade secret protection. Another common area of trade secret protection is customer lists. So if you've got an employee that works for you that has access to your customer list of customers, that customer list is often kept as proprietary or trade secret information, so that that employee can't leave you, go work for someone else, take your customer list, and immediately start calling on those customers. That's information that they've gained through your business, through working for you, and not something that's publicly available. So long as you've taken reasonable steps to protect that customer list, it should qualify as a trade secret. I think that covers everything for today with regard to trade secrets. Thanks for watching, and we look forward to talking to you again next week.